You should never plan your own estate. Legal documents are rampant in today's do-it-yourself era, where a click of the mouse allows you to find out how to do virtually anything on your own. They promise you peace of mind without the necessity of expensive legal fees or even setting foot in an attorney's office. DIY estate planning can have unintended consequences that may be costly and time-consuming for your family to remedy long after you have passed away. Over the next few minutes, I'm going to share why DIY estate planning is not a good idea. I'm Mitch Greene, a partner at Kramer, Greene, and for the past 35 years, I've helped business owners in various industries, including healthcare, protect their businesses from unforeseen circumstances. If you're trying to protect your assets or business and need legal assistance, I'd like to help you create that playbook. So visit my website and schedule a complimentary consultation, and I can walk you through your options. Now, let's review the 5 things to consider before taking on DIY or do-it-yourself estate planning. 1. Florida has specific laws that govern the legal validity of estate planning documents. Like every state, Florida has laws that outline specific requirements for the legal validity of certain documents used in estate planning. Florida statute, section 732.502, provides for certain execution requirements that wills must meet to be legally enforceable documents. All too often, DIY estate planning documents fail to incorporate the requirements required by state law. With legal counsel, you can ensure that the documents are legally valid under Florida law. Furthermore, as state laws change over time, there is no way to ensure that DIY forms found on the internet are updated to reflect these changes. 2. DIY estate planning documents typically use a one-size-fits-all approach. Everyone's situation is unique, and some situations are more complex than others. Therefore, if you have a complex family dynamic or unusual situation, these forms will not likely meet your needs. 3. DIY estate planning can have catastrophic consequences. Suppose you use DIY estate planning products to draft a will. If you pass away and the will you executed turns out to be legally invalid, then it will be as if you passed away without a will or intestate. Therefore, your property will be distributed according to Florida's intestacy laws, which may differ from how you wanted your property to be distributed. 4. DIY estate planning could increase the likelihood of a will contest. If your DIY estate planning fails to distribute property as you intended, your surviving family members may be more likely to challenge your will through a will contest. These proceedings can be lengthy, expensive, and reduce your estate assets. An extreme example of this is the estate of rock legend Prince. As discussed in a prior video, a will contest in his estate, where he did not have an estate plan, cost his family members tens of millions of dollars, with them ultimately receiving a relatively small percentage of his entire estate. 5. DIY advance directives could result in costly and unintended results or require costly and burdensome guardianship proceedings. Advance directives allow you to choose certain individuals to make decisions about your health care and the handling of your financial affairs if you become incapacitated or you're unable to do so. When executed properly, advance directives can prevent the need for guardianship proceedings, which can be costly and burdensome, particularly when quick decisions need to be made. I hope this video provides you with a better understanding why you should not use do-it-yourself or DIY estate planning. Whether you're trying to protect your assets, start a business, sell a business, or navigate the laws within a business, we can provide a one-stop option for everything. If you have questions surrounding your business and legal needs, schedule a time to meet with our firm today and take the first step in protecting your business and financial future.